Hi, everyone. Welcome. Thank you so much for joining us tonight. I'm Jessica Dickinson. I'm the program manager for the Ohio Fair Courts Alliance, and we've got a great presentation for you tonight. Sadly, this is our last webinar in our Fair Courts and the Environment Summer Series, and we have been so lucky to have partnered with Chris Tavenor and the Ohio Environmental Council to do this. So thank you, Chris. It's been a real pleasure working with you. Our moderator this evening is Maria Bruno. She's the co-founder and executive director of Ohioans Against Extremism. And I'm going to send it over to her to introduce our panelists.
Hi, everyone. Thank you so much for joining us tonight. As Jessica said, I'm Maria Bruno. I'm really thrilled to be moderating this conversation. In our prep call, I was nerding hard out with Chris and Erica, so I'm really excited to do that with all of you tonight. So I'm going to dive right in with the panelist biographies, which are very impressive. First, we have Chris Tavenor. Chris is the general counsel at the Ohio Environmental Council. Chris leads the OEC's Law Center while providing essential legal support to the entire organization. They also coordinate the annual Ohio Public Interest Environmental Law Conference and legal internship program. Over their time with the OEC, Chris has represented the organization before the Ohio Supreme Court, the Public Utilities Commission of Ohio, the Ohio Power Siting Board, and beyond. Chris received their bachelor's degree and law degree from Ohio State. Beyond their work as an attorney and advocate at the OEC, they are also a science fiction and fantasy author, publishing works under the name C.D. Tavenor. So you should definitely check that out if you are a sci-fi nerds. We also will be hearing from Erica McConnell. Erica is a senior attorney at ELPC. She is based in Columbus and focuses on clean energy issues across the Midwest. Her areas of expertise include shared community renewable energy, net metering, solar permitting, grid modernization, interconnection, and renewables integration. Erica received her law degree from the University of California, Berkeley School of Law, and received a Master of Environmental Management degree from Yale School of Environmental and the bachelor's degree in Ethics, Politics, and Environment and Economics from Yale University. So we've got some very smart presenters here, both of which have extensive experience navigating the bureaucracy that is energy law. So I'm going to let Chris dive right in here. And reminder that you can put any questions in the chat, and we will have time at the end of this session.
Thanks, Maria, and it's great to be back with everyone, with Jessica and Mia and Catherine with the Ohio Fair Courts Alliance. Be with you all. So today we are focused on understanding the intersection of state agencies, the courts, and your utility bills. Just a few kind of logistical things right at the top. We did accredit this webinar for continuing legal education credit like the last one. So if you are an attorney, you can get credit for listening to this. We will have some poll questions throughout the webinar that are one kind of just there for engagement for everyone. They should be interesting poll questions for all. So please engage with those. But for those of you that want CLE credit, you got to do those questions to make sure we can track your attendance throughout the hour. And then also just one quick plug right at the top, especially if you end up enjoying this session and the deep dive into utility issues at the Public Utilities Commission. The Ohio Environmental Council at the end of next month is hosting our Ohio Public Interest Environmental Law Conference on September 25th. And then we also have a utility advocate convening the day before on September 24th. And both of those issues are going to be on a lot of related things. The utility advocate convening is about all issues at public utilities commissions. It's a deep dive if you really want to become an expert on how to do advocacy at public utilities commissions. And then our law conference on Friday, the 25th, is all about data centers. So really hope if you really want to dive more deeply on all these issues, you can join us there. All right, moving to the next slide. So this is our first poll question to test to make sure everyone knows how to do these, but it kind of gets us started to get a little bit of a baseline knowledge of folks on how much they know about where they get their electricity from. So Mia, if you could start that first poll question, what Ohio electric distribution utility provides you with your electricity? And I can't vote. It doesn't let me vote right now, but I'll just name it out loud for myself. I get my electricity from AEP Ohio. because, well, I won't say why I know that because it'll actually give it away for some folks. I'll see if you all know. We can probably leave it up, Mia, for like 20 to 30 seconds. But while people are answering, electric distribution utilities, that's the main type of the main type of utility that we're going to talk about here today. And we're going to be focusing our discussion on the Public Utilities Commission of Ohio and the Ohio Power Siting Board. These are two state agencies that they intersect with the courts a lot more directly than some agencies do, in the sense that all decisions of the Ohio Power Siting Board and the Public Utilities Commission of Ohio get appealed directly up to the Ohio Supreme Court. And we're going to talk a lot about that and what those entities are. And it looks like, okay, great. So most people are in, as expected, the main four utilities of Ohio. That's AEP, Ohio, First Energy, Duke, AES. We got a few people who know they're on a municipal utility. Looks like we've got no electric cooperative folks. The rural electric cooperatives are often out in rural parts of Ohio, and they are not regulated by the Public Utilities Commission. And then someone put something else. And so maybe if somebody is curious on, I'm kind of curious what folks are thinking when they put something else. All right, next slide, please. Okay, so the Public Utilities Commission of Ohio. I'm going to do a little bit of just ground setting to make sure everyone understands what each of these entities are. So the Public Utilities Commission of Ohio is made up of 5 individual commissioners that are appointed by the governor. There's a complex entity called the Public Utilities Commission Nominating Council. We're not going to really get into what their role is, but they're kind of an entity that helps nominate people for the governor to consider for appointments for the PUCO. But what's important for you to know is that these 5 individuals, they're not elected, they're appointed by the governor, and they are the 5 individuals who make Public Utilities Commission decisions. But what's really interesting about these 5 is that they play a quasi-judicial role. Their decisions that they make are written like judicial opinions. And those of you who have paid close attention to, say, the Ohio Supreme Court over the past few years may recognize one of the names on this list. Jennifer French used to be on the Ohio Supreme Court. And so this group of people, any public utility decision that comes out of the state of Ohio when it comes to the major electric utilities, it's these 5 individuals that are making the decisions. The cases that are put before these 5 individuals are overseen by what are called administrative law judges. The administrative law judges actually run the hearings, they run the cases before the Public Utilities Commission. They're often doing a lot of the research and drafting for these 5, but these 5 are making the final decisions and telling the ALJs how to rule in the case after the ALJs are kind of presenting the evidence to the commission. All right, next slide, please. So then the Ohio Power Siting Board is the entity that is designated to review all electric generation cases in Ohio that are larger than 50 megawatts. So electric generation projects that are smaller than 50 megawatts, which might be like a small community municipality is putting together a solar array that's maybe like 10 to 20 megawatts. It doesn't have to go through the Ohio Power Siting Board, but anything over 50 megawatts does need to go through this board. And this board is a little bit different than the PUCO for a variety of reasons, but one important connection is that the chair of the Public Utilities Commission, Jennifer French, she is also the chair of the Ohio Power Siting Board. And then the other main members of the Ohio Power Siting Board are actually agency heads. You can see here, you've got Department of Natural Resources, you've got Department of Health, the Director of Department of Development. Those positions are locked in as members of the Ohio Power Siting Board. And then there is one other public member that the governor appoints, as you can see there in the top left. But then the Ohio Power Siting Board also has a bunch of non-voting legislative members that participate in the meetings, comment on them, but don't actually have a vote in the decisions of the Ohio Power Siting Board. And then it gets even a little bit wonkier, where in certain types of cases, solar and wind cases in particular, county commissioners have the ability to appoint township trustees to then participate in those renewable energy cases as voting members in those cases. All right, next slide. So what's important to kind of just frame up the discussion for you all as we get toward the connection between these two agencies and the court is kind of what that process looks like. So the Public Utilities Commission of Ohio sees cases from electric distribution utilities. That's where Erica and I work the most, is with electric distribution utilities. But there are also a whole bunch of other utilities that they regulate as well. So railways in Ohio get regulated by the Public Utilities Commission. Telecommunications, there's a whole bunch of other stuff. We're mostly focused in this conversation on electricity, though Erica will talk a little bit about a gas case, I believe, that they've worked on because they also regulate natural gas. But then also consumer complaints. So if individuals have a specific complaint against their utility, they file that with the Public Utilities Commission and it moves up through that system. Down at the Ohio Power Siting Board, the Ohio Power Siting Board is reviewing all applications for electric generation that I mentioned that are larger than 50 megawatts. Transmission lines go through the Ohio Power Siting Board, so the big electric lines that are kind of cutting across the state. And then also pipelines for natural gas that are intrastate. So pipelines that are totally contained within the state and don't cross state lines, they also go through the Ohio Power Siting Board. After the PUCO or the OPSB make a decision, and their processes are pretty similar because the OPSB is kind of technically nested under the PUCO, but also separate. It's a little bit of a weird staff overlap. Once either entity makes a decision, any party that is part of that case can file what's called an application for rehearing. And so then the PUCO and the OPSB is actually required to take one last look at it from that application for rehearing. Most of the time, applications for rehearing are just uniformly denied by the PUCO and OPSB, though I might mention this case a little bit more later. There was actually a case just today where the PUCO actually granted someone's application for rehearing on a case related to First Energy, but that's super rare. Same with the OPSB, it's almost never the case. So the application for rehearing is mostly just a procedural step, and then a party can appeal their case directly to the Ohio Supreme Court, skipping all of the other courts. So they don't go to the trial court, they don't go to the Court of Appeals, they go straight to the Ohio Supreme Court. And so that means these two agencies, and this is not most agencies do, I think there's one or two other state agencies that do go directly to the Ohio Supreme Court, but generally speaking, having these decisions be appealed directly up to the Ohio Supreme Court means that the one court where all Ohioans vote on every single judge, that court hears all of these decisions. And what's also curious and interesting about these cases, it's not discretionary. The Ohio Supreme Court has to take these cases. Other cases that are getting appealed up from the appellate level of the courts, those cases don't have to be heard by the court. The court can choose to decline hearing those. Every single case from the PUCO and the OPSB must be heard by the Ohio Supreme Court. All right, next slide. So we're gonna do our second poll question, and then I'm gonna shift it over to Erica to start diving a little bit deeper into some cases, so you can kind of see the interplay between the commission and the Ohio Supreme Court. So this is another kind of opinion question. Why do you think your electric bills are rising? And Erica, as we transition to your section, what is your maybe not, what's your number one reason on this list, would you say?
Oh, that's hard, Chris, to pick one reason, because I do think it is all of the above. I will talk a little bit about data centers at the end of my remarks and how they are affecting our electricity bills. So there's a little preview for everybody.
Yeah, good. Everyone put all the above, generally speaking. All of them are relevant, though, and some of them are definitely playing more of a role than others. All right, take it away, Erica.
Thanks, Chris. Hi, everybody. Again, I'm Erica McConnell. I'm an attorney with the Environmental Law and Policy Center. You can go to the next slide. I wanted to start with a little bit about ELPC. For those who aren't familiar, we're a Midwest environmental legal advocacy organization, and you can see our geographic scope on this slide, which includes our office here in Columbus. I'm on our clean energy team, and we have several other program areas, including clean water, clean air, clean transportation, and a few others. Next slide. So I wanted to start by building off of what Chris already shared about the PUCO and explain a little more about the case process at a high level before we reach a Supreme Court appeal to help provide some context for the 3 appeals I'm going to talk about. First, I want to highlight that in all PUCO cases, there's always an opportunity for public participation, and that's separate from actually intervening in a case and participating as a party with a right to appeal, which is what ELPC and OEC do, and which is resource intensive. But there's a direct role at the PUCO for the public to comment too, which is important because at the end of the day, it's we, the public, who are impacted by the PUCO's decisions, including through how much we pay on our utility bills. So as far as the case process, it's also important to know that many cases are settled via stipulation, where signatory parties agree to various terms. And when this happens, the PUCO has a 3-part test that it always uses to evaluate stipulations, which is on this slide. And in some, it's 1, whether they're a product of serious bargaining, 2, whether they're in the public interest, and 3, whether they violate any important regulatory principles. And if that sounds a little kind of squishy to you, that's because it is. It relies heavily on the PUCO's judgment and discretion on a case-by-case basis, including in how the commissioners balance the various terms and interests within a settlement package. And then finally, and Chris kind of already touched on this, but whether a case is fully litigated or settled by stipulation, the PUCO reviews the record and must file, it issues an order deciding the case, and then before appeal, parties must file applications for rehearing. So that's the last step at the PUCO before an appeal to the Supreme Court. Next slide. Oh, I think we might have skipped one of my slides, but I guess, okay, that's okay. What the slide was the statutory language for the appeal. And what I wanted to highlight with that was the standard for the appeal, which is a pretty high bar. It is to show that the PUCO order was unlawful or unreasonable. And on questions of fact, specifically, the court gives quite a lot of deference to the PUCO. So the PUCO, their role remains very powerful even once we've reached the appeal process because of the deference that it gets from the court. So the first appeal I want to talk about today is Moraine wins. And it's not for the substance of the case, it's actually for procedural reasons and what it shows about how the court views its own role versus the PUCO and the legislature in decision making. So this slide lays out the basics of the case, but what I want to hone in on is the application for rehearing. And again, that's the last step at the PUCO after its order and before a Supreme Court appeal. So in this case, the PUCO granted a party's application for rehearing within the 30-day statutory deadline, quote, for the limited purpose of further consideration of the matters specified therein. And they didn't really say any more than that. And for context, this was pretty common practice at the PUCO. They viewed this kind of grant for further consideration as satisfying the statutory requirement to grant or deny applications within 30 days. But many parties felt that by doing this, the PUCO was effectively and improperly giving itself an indefinite extension of time of the statutory deadline to take action on rehearing, and then in turn effectively indefinitely stalling any appeals because parties have to get through that application for rehearing before they can appeal. So as you might imagine, many parties didn't like that. Next slide. So in this instance, CSG, the Carbon Solutions Group, filed an appeal on the substance, but also to test this process question. And without going into the procedural details, the court agreed with CSG and basically told the PUCO that it couldn't continue with its practice of granting applications for rehearing for further consideration and extending its own statutory timelines beyond what the legislature had said. And you can see with this quote on the slide from the court's decision, the court emphasized that the legislature set the timeline to ensure that parties can get timely judicial review of PUCO decisions. And it went on to say that it is It's not for this court to create judicial end runs around clear legislative commands. So I realize this is a little down in the weeds, but moraine wind really had big implications for how the PUCO manages its cases and how the appeals process works. And based on its reading of the legislative language, the court took some degree of power and discretion away from the PUCO with its decision here and forced the PUCO to make substantive determinations on the merits about applications for rehearing within 30 days and said no more of these grants for further consideration. Next slide. So moving on, I want to highlight a case that ELPC was involved in, the Columbia gas rate case, which has a more clear and direct bearing on customers' utility bills. And it also shows how much power the PUCO does continue to hold in the appeals process. And again, as Chris kind of previewed, this is a gas utility, not an electric utility. But all utilities file rate cases like this at the PUCO to propose customer rate increases, and they often involve related rate and program proposals as well. In this instance, in addition to proposing rate increases, Columbia Gas made proposals related to its energy efficiency programs, and it also proposed to very significantly increase the fixed charge that customers have to pay on their gas bills. And you can see an example of what I mean by fixed customer charge here. This is actually my actual Columbia gas bill from last summer. And at the bottom, you can see I'm not using much gas, and I have a relatively low charge of just over $9. And that's based on the amount of gas I'm using. So when I use more gas in the winter, when my furnace is on, that charge is going to go up on $1 per therm of gas basis. And then at the top, you can see my fixed monthly delivery charge, and that charge does not change. So no matter how much I use or how much I don't use, I pay the same amount every month. And then the charges kind of in the red box below are also fixed costs that don't change by usage. So at the time of this bill, Columbia Gas customers like me had to pay about $53 before they used any gas. And among many other provisions, the stipulation in this rate case, which the PUCO approved, allowed Columbia Gas to raise that fixed charge all the way up to be about $58 by 2027. And for context, it was about $36 before the utility filed the rate case, which is actually already pretty high when you look at other utilities, but it's a big increase nonetheless. And in addition to that, the utility agreed in the stipulation to eliminate all of its energy efficiency programs except for a limited low-income program. So this decision left customers with a very high charge they can't avoid every month on their bills, and without the efficiency programs to support their efforts to lower their usage through the usage charges. So ELPC and CUB, the Citizens Utility Board of Ohio, opposed the stipulation at the PUCO and ultimately appealed the case up to the Supreme Court. Next slide. So on appeal, we argued that the PUCO's approval of that significant increase in the customer charge, plus the removal of the efficiency programs, violated the PUCO stipulation test and was therefore unreasonable and unlawful. Specifically, we argued that the test or that the decision was not in the public interest and did not benefit customers, and also that it violated regulatory principles, including principles around promoting efficiency and fairly allocating costs to customers. Unfortunately, the court denied our appeal this summer, and they found no reversible error. And in its decision, the court gave a lot of deference to the PUCO's evaluation of the facts and its balancing of the various components of the stipulation beyond the two issues that we focused on. So this is an example of the high bar that appellants like us have to overcome when appealing a PUCO decision, like I was talking about earlier, especially when it comes to stipulations. The court gives a lot of deference to the PUCO, especially on questions of fact. And then on top of that, the PUCO has a lot of discretion within its stipulation tests in making its decision below. So while judicial review is very important, appellants do sometimes prevail. When we're thinking about customer bill impacts, we need to be putting in a lot of work at the PUCO in the first place to try to get it right there. Next slide. So finally, the last case I want to talk about is AEP's data center tariff, which is actually pending on appeal at the Supreme Court as we speak. For those not familiar with the lingo, a tariff is basically the utility's official rulebook and pricing plan that it uses to calculate customers' bills. So, for example, there's a residential tariff at your utility that you pay your bills under, and AEP also has this tariff specifically for data centers. And I included these graphs here to illustrate some of what this data center tariff is responding to. So on the top, we're looking at electricity demand, and you can see that the commercial sector's electricity demand, that's the orange line, is going up higher and faster than both residential and industrial, and that's driven in large part by data centers. And then on the bottom, we're looking at electricity prices, and you can see that residential customers, the blue line, are seeing their prices go up higher and faster than both commercial and industrial customers. So these are national averages, but they generally speak to the growing concerns in Ohio and across the US over increasing data center electricity demand at the same time as we're seeing increasing electricity prices for customers, especially residential customers. And what this AEP tariff is trying to do is to make sure new data centers are paying their costs and not unfairly saddling residential and other customers with those costs and further increasing their prices. So as you might imagine, this PUCO case got a lot of attention from everybody, including from data centers. There were several of them represented in the case. And it ended up that there were actually 2 stipulations filed, which I'm not sure has been done before, or it's very rare. One was from AEP PUCO staff and the Office of Consumers Counsel, that's OCC, which is the state-sponsored residential ratepayer advocate. And the other stipulation was from data centers and some other parties. And the PUCO ultimately approved that first stipulation from the utility, OCC, and staff, saying that it better satisfied the public interest prong of its test, and it was the only stipulation to satisfy the regulatory principles prong. Next slide. So the Ohio Manufacturers Association Energy Group, OMAEG, which represents energy-intense manufacturers, appealed this decision. And like I said, it's still pending up at the Supreme Court. And their main argument is that the data center tariff is unlawfully discriminatory because it specifies a customer type. It specifies data centers rather than identifying a class of customers based on their cost to serve. So in other words, there could be customers that aren't data centers per se, but that they have the same characteristics, they cost the utility the same to serve, and therefore they should be subject to the same tariff. So OMAEG in its appeal also, in addition to that, takes some issue on the PUCO's reliance on speculative load forecasts and transmission system constraints that they're alleging that OMAEG says aren't sufficiently justified. Like I said, this case is in process, so it remains to be seen what the court is going to do with it. But if the court agrees with OMAEG, then likely that means, like in Chris's kind of original diagram, it goes back to the drawing board at the PUCO to revise the tariff, and that in turn could have implications for how utility costs are allocated to data centers versus other customers. Next slide. So in the meantime, there's the other 3 regulated utilities in Ohio are in the process of putting into place very similar data center tariffs. Those are the first 3 cases listed on this slide. And then we're also seeing other PUCO cases addressing other elements of data center electricity service, including the last listed AEP case, which addresses how to navigate competitive versus default supply for these customers. The PUCO recently issued an interim decision on that. And I expect we're going to continue to see more data center related cases at the PUCO, and then we'll just have to wait and see if any of it makes it up to the Supreme Court. Last slide, I think, is my very last one. Yeah. So thanks everybody for the chance to speak with you, and I'll hand it back over to Chris.
Thank you, Erica. I know I've been seeing some Q&A coming in. A variety of people keep asking about SB 52. I'm going to be talking about that here very shortly, so hang tight. If you could go to the next slide, we have a really quick, this is actually a knowledge test question. There is a right answer, but for our next poll question, who appoints PUCO and OPSB members? It is, yeah, there is a right answer here. I'm curious if people paid attention earlier. We're not testing for knowledge, though. If you get it wrong, that's okay. So I'm going to be moving us toward some cases that are focused on some specific types of electric generation. So the first one is actually going to be a PUCO case, and I can talk a little bit about the history there. But then I will be talking about some OPSB issues, Ohio Power Siting Board issues. And then ultimately, that's going to pull us into this kind of closing conversation where talking about how all of these cases at the PUCO and OPSB and the interplay between the Ohio Supreme Court, how all of these decisions of the Ohio Supreme Court have a direct impact on our utility bills, electric bills, gas bills, what they might be. The correct answer here is yes, PUCO members are appointed. The OPSB is a bit more complex because the governor does appoint all the members of the OPSB, but it's also just the agency heads are automatically on the OPSB. And then also there's those non-voting members. And then also in certain cases, you've got some local elected officials who end up on the board just for those decisions. So it's a little bit more complex than just the governor appointing everyone. All right, next slide. So the first case that I'm going to talk about is, and this is a little bit of a mouthful, and that's not even the full title of the case, INRI OVEC generational purchase rider audits required by RC 4928.148. What that means, because Supreme Court case decisions can sometimes be not really comprehensible, that is about the Ohio Valley Electric Corporation coal plants that maybe some of you have heard of before. There's two major coal plants that are part of the OVEC corporation, where these are old legacy coal plants originally built to power the Piketon uranium enrichment facility down in southern Ohio. They then became power plants to power the grid generally. They're very old, they're very expensive, and during in House Bill 6 back in 2019, the Ohio General Assembly codified a bailout for these coal plants through what was known as the Legacy Generation Rider. And then through that Legacy Generation Rider, this bailout of these coal plants, the Ohio General Assembly required the Public Utilities Commission to audit the operation of these plants to confirm that any costs that were being passed on to customers, aka all of us, were reasonable and prudent. And what the case I'm going to talk about here is Ohio, the OEC, Ohio Environmental Council. We appealed the PUCO's determination that the costs were reasonable and prudent. We appealed that up to the Ohio Supreme Court. Erica mentioned OMAEG, Ohio Manufacturers Association Energy Group. They also appealed this case up to the Ohio Supreme Court for slightly different issues than us. Some of them were overlapping. This case was decided just a few weeks ago. And actually, I think it's more like a month and a half to 2 months now. But ultimately, OEC, we lost this case and won on a slight part on a technicality. But it's an important case to kind of show the really complex interplay that comes with how the Ohio Supreme Court oversees the PUCO and kind of guides how the PUCO makes its decisions. So what we were objecting to with the OVEC audit was saying, hey, PUCO, you didn't assess the evidence correctly. That's kind of the easiest way to put it. It's a little bit more complex than that, but we don't have a ton of time to get into all the details. And what the Ohio Supreme Court ended up ruling was that the commission did not commit reversible error in its review of the audits and when it permitted those costs. However, the commission did err in applying what's called a presumption of prudence to the utilities. So that was one of our big arguments at the OEC, was that essentially the PUCO was kind of just presuming that the utility was prudent unless evidence said otherwise. And we were like, no, the utility's got to prove their case that what they're doing is prudent. But So the Ohio Supreme Court agreed with OEC on our legal position that they should not be giving the utilities a presumption of prudence. But what the Supreme Court then went on to do was say, but even though the commission was applying this presumption of prudence, they still looked at enough evidence for it not to matter, which was an unfortunate outcome. So it's a little bit of like a moral victory where we won on the law, but we lost on the facts. But the reason why I'm bringing this case up is it shows how these things can be super nuanced. What I will say is the win that we got here, that the commission cannot just presume the prudence of the utilities and how they were charging customers for these costs, will hopefully have an impact in future cases where we can call them out, the commission out, when they try to do this again in future cases where they're kind of just presuming that what the utilities are saying is true. Next slide. So next I want to go towards electric generation cases. This is Oak Run is a giant solar project proposed in Madison County. This is an OPSB decision. The Ohio Power Siting Board had approved this case at the board's level. Some opponents to the project appealed the decision up to the Ohio Supreme Court. Ohio Environmental Council, we were intervened in the case at the board, and then we filed an amicus brief in support of the board's approval up at the Ohio Supreme Court. And this was a case that honestly was a little surprising that the court ruled the way they did. But it gives a little bit of an indication of how, once again, the court is actually looking pretty closely at the way that the Ohio Power Siting Board is making its decisions right now. The court approved almost everything that the board did, but focused on one specific prong of the board's review of Oak Run and said that the applicant, the company that put forth Oak Run, didn't provide enough information around public vantage points to determine adequately the visual impacts of the proposed project. So this is a super specific factual determination that the court kind of intervened in, kicked the project back to the board. The board actually just had the evidentiary hearing on the new visual studies just a few weeks ago. It's currently finishing up briefing, and the board will be making a new decision based on just that. It's literally only on that question of whether or not the visual impact is sufficient now that the data that has been provided. What is important about this case, though, is that over the past few years since Senate Bill 52, people have been asking about that in the chat, the Ohio Power Siting Board has been disapproving a lot of solar projects for a variety of reasons. And also wind projects have kind of stalled for similar reasons, but also some other reasons too, given some other historical issues in Ohio law. But the Ohio Supreme Court has been generally approving most solar projects that make it up to them. This was one of the first projects where one that the board had approved, the court actually said, no, you got to fix something with it. This is the largest solar project ever be proposed in Ohio, so that may have played a little bit of a role in it. It also could indicate that the board is starting to just take an even closer look on all the solar cases. What we don't currently have, and you can go to the next slide, is a case where the board has denied the project, the applicant has appealed that up to the Ohio Supreme Court, and the court rules on that denial. But we do have one that is active at the Ohio Supreme Court that we've been waiting approval on for a very long time, called Kingwood Solar. One of the reasons why we don't have a lot of these decisions is that most of the projects that when they get denied by the board, the companies just pull out. They don't even appeal. There's actually a procedural step at the Ohio Power Siting Board, at the way that the board has been reviewing projects, where if the staff of the board recommend denial of the solar project, then the applicant will just close their application then and there and step out. So we aren't getting a lot of legal decisions from the court on the logic that the board is using to deny projects. But Kingwood Solar is one case that has been sitting before the court for a very, very long time. And I want to really actually kind of emphasize this point because it was originally appealed up to the Ohio Supreme Court November 11th, 2023. The board had denied it on the basis of some of the ways that local governments near the project were viewing it. Oak Run was appealed 1 year later and has been decided already. It was decided a few months ago, and Kingwood is still sitting there. And just today, the Ohio Supreme Court did rule in a procedural motion in that case because it had taken so long for the Ohio Supreme Court to review the case. The Ohio Power Siting Board actually filed a motion at the court saying, hey, Kingwood has lost its place in the PGMQ. They probably can't even build their solar project anymore. So you should just dismiss this case as moot, which, interestingly enough, the court actually denied that motion. So they still are hypothetically going to rule on that case, but they still haven't yet 3 years out. And then just a few other notable cases to kind of name as we shift into kind of discussion and Q&A. One case that we're eyeing pretty closely is the Ports Energy Center. It's just been proposed at the OPSB, and it's going to be the first of probably a variety of projects, all related to a very large data center down in Portsmouth. A bunch of natural gas projects are going to be proposed, probably some pipelines, some transmission lines. And that's going to be a big project that how that moves through the board, there will probably be a variety of different cases that get appealed up to the Ohio Supreme Court. And then we have this general question of the definition of public interest at the Ohio Power Siting Board, as I was just kind of talking about. Because cases that get denied at the board, oftentimes the company just kind of pulls out of the project. We're not getting a lot of these legal questions appealed up to the court in a meaningful way because the applicant, the company, is really the only party that can appeal a denial upward. And then also reliability standards are another case I just wanted to note where the PUCO is actually holding the utilities to a pretty decently high standard. They're holding First Energy to a high standard in a recent reliability case. But the Ohio Consumers Council is actually appealing that decision to argue that the PUCO should have gone even further than they did when the company was asking for a significant relaxing of the standards. All right, next slide. I believe this is oh yes, okay, so this is my kind of final diagram, and then we'll go into discussion where how do OPSB cases impact your electric bill? We haven't really talked about that. And this is my really rough diagram that I put together a few days ago, where on the left, you have all the different electric generation that is going into the grid. And then I've got this little gray circle down on the bottom that is denied renewable energy projects, because over the past 5 years or so, we have seen a ton of solar projects denied by the Ohio Power Siting Board. And so over on the right, just imagine all those gray dots represent houses and businesses. And up until maybe 21, 22, 23, the denial of those renewable energy projects was going to have an impact on your bill because more electricity is going to make it cheaper, but it wasn't as significant. But we've got this new kind of wild card variable in play, which is all of these data centers that are proposing to use a ton of electricity. And so then you've got the grid, the electric distribution utilities, the transmission grid predicting a significant larger amount of demand of electricity over on the right side, but we're not building more on the left side. And there's a little bit of a problem of our own making here. I say "our" loosely, where a bunch of electric generation that's been denied over the past few years could have been accounting for some of the increase in demand, those renewable projects, and could be keeping our electric prices down. But that's not the situation we have right now. Next slide. So this is our last question, and this is mostly just curious. If folks know, we didn't really talk about this issue at all, but this is kind of just to see what people know. Do you know who supplies your electricity versus separate from your electric distribution utility? Some folks may know this. And Maria, while people are answering this question, you can probably get us started on our first discussion question.
Perfect. I have so many questions. And I know that we only have like 15 minutes, so I'm sitting here looking at my long list, deciding what's most important. I just have, I guess, like I'm going to combine two, and you can just tell me whichever is more important of these things. But one thing that when you're explaining these cases, I was struck by the part about the visual impact being the thing that actually canceled a project. And like, does that literally just mean what it looks like? And is what's going on? I
So
mean, that
great
feels the least
question.
important thing.
Yeah, so great question. It's even more nuanced than that. And to be clear, Oak Run is not canceled. The board, I would predict the board is likely to approve it with the new data that they've provided. But essentially, what the court said was super hyper specific, which was that the Oak Run didn't provide sufficient visualizations of what the project will look like
Okay.
in order for the board to make an accurate determination as to what the visual impact would be. A solar project can have a visual impact on like people's view sheds, but the board has to know what that's going to be before they make their determination. And the court was like, you didn't provide sufficient visualizations to make that determination. It's super specific,
Fascinating. Okay,
super
sorry.
specific
Yeah,
fact
that just like
determination.
stuck out
Yeah.
to me as like, what do you mean? And then the Kingwood Solar one was so weird to me. So this is a very important or very significant case, it sounds like, that's been pending
Yeah.
forever. Other cases have started and finished while that's pending. Now they even tried to just altogether pull out and they're not letting them. Can you like dive into that more? What is going on? What's your theory of what's happening?
Yeah. So Kingwood is a really weird case. And there's like not enough time to get into it, but what I will say is, there's some really interesting partisan back and forth on the court's docket itself, where you've got this was years ago now, but it's just to illustrate how weird this case is, and it may explain a little bit of why the court hasn't made a decision. You had a bunch of Republicans weighing in with amicus briefs telling the court how to decide. And then the Democratic caucus at the legislature then also put in their own amicus brief. And then the Ohio Attorney General tried to say that the Democrats couldn't put in their own amicus brief. And then the court said was like, you all need to shut up. Everyone's opinion's fine. We'll take it in and assess it as we need. But it was this very interesting kind of back and forth that kind of just indicates that like people know the significance of this case. They were trying to like put forth different interpretations of how SB 52 impacts the decision. But at this point, it is just very odd they haven't made a decision yet. And Eric, I don't know if you have any other additional thoughts on it.
No, nothing to add.
Cool. Well, that's kind of a perfect segue, I think, actually, into what I wanted to round out the conversation talking about. Um, pending legislation obviously matters. We didn't really have time to dive into all the different ways that the law might change next time we have this conversation. But as someone who's viewing this who doesn't themselves litigate cases, and you're sitting here seeing all these significant decisions being made, you can certainly feel like there's nothing you can do to change what's going on. And I'd like to dispel ourselves of that illusion. So, I mean, there is a big election coming up. This is a nonpartisan space, and this is not about, promoting one candidate or not, but I think it would be helpful for us as voters to, be able to educate ourselves about candidates and about the role of courts. And Attorney General's office was mentioned, the governor's office was mentioned. There are ways that these elected offices interact with this. So, like, as a voter, let me just ask more generally, are energy issues one that just fall on partisan lines? Like, can you just kind of look at it through the standard Democrat versus Republican lens, or is there some other way that we should be thinking about this as voters?
My quick answer, and Erica, I'm curious your answer on this is I would say that no. Energy issues in Ohio in particular, they're okay. I will say when you look at the legislature, like the legislature, it's very easy to say, like, oh, the Republicans don't like renewable energy and the Democrats do. It's a little bit more complicated than that, but like the Republican Party pushed for SB 52 to move through. But when you look at the court, the way that the court has kind of managed the Public Utilities Commission and the Ohio Power Siting Board, a lot of the decisions that come out of the court include right now we only have one, Democrat affiliated justice, but often they're pretty unified together on these decisions. And I would say there's kind of a general trend over the past 6 years or so of the court trying to make sure that the board and commission follow their rules and hold accountable the utilities in some fashion. I think Erica and I may disagree sometimes with how they they do that, but I do think they are to some extent, there's a little bit more of a trend versus what maybe you might see like 10, 15 years ago. And the point I'm kind of trying to make is that like energy issues are so complex that like how a judge is going to approach those is probably a little bit of a different philosophical question that you really like if you're going out and talking to a judicial candidate, you got to get a lot more nuanced with them about how they might approach overseeing a body like the Public Utilities Commission or the Ohio Power Siting Board.
Yeah, I totally agree with all of that, Chris. And then at the same time, I also remember that judges are also utility customers and they pay their bills. And I think as, affordability is becoming this sort of top line issue, I think it's impacting everyone directly. And as we are making arguments at the PUCO and at court, we have that in mind too, that can clean energy, like Chris was showing us in their diagram, improve affordability for customers. If we were building these facilities, could that have driven down our bills? If we had more energy efficiency, could that drive down our bills? Is that in the public interest? So, I do think remembering that their people paying their bills can kind of affect our thinking about this. But I also agree that it is somewhat of a philosophical question around how they think about the role of the court versus the role of the agency and the technical expertise of the agency. And that really impacting a lot of this stuff is more going to happen, I think, at the agency level where you have that technical expertise.
And I think that's the important thing to note is like, who is governor decides the people that are actually on those entities, then those decisions that get appealed up to the court.
So what kind of questions would you all recommend? Given, again, it's not a Democrat, Republican, easy to predict, view of the courts. How can we suss out, what these candidates might do with their power? Like what kind of questions could we even ask them as voters and sort of get them on the record to try to understand where they would lean on this?
I mean, I think asking what do they think public interest means in the context of energy is actually a really important question to understand how they might think about these issues. Like if you have the opportunity to talk to a Supreme Court justice, someone who's running, asking that question, I think will tell you a lot. Because one of the things that we're constantly arguing for, both at the Ohio Power Siting Board, but then also up at the Supreme Court, is that like an issue like climate change, a project's impact on whether or not it's going to reduce the causes of climate change should be a factor in the public interest. And current reality in Ohio is that both the board and the court kind of just ignore that question entirely.
You took my idea, Chris. It was to ask about the public interest, and now my mind is blank. So I totally agree with what you just said.
Well, Erica, I'm curious what you would say when it comes to that super wonky settlement issue. Like I'm almost like that. I don't know how you even create a question out of it, but like that settlement standard that we have, we have a colleague that really thinks it should be torn apart because it creates a lot of problematic decisions.
Yeah, I mean, I do think a lot of that comes back to the public interest, though. Like that's the second prong of that standard. And frankly, it's the most important one. It's the one that the commission spends the most time kind of balancing the evidence on. And so I think kind of understanding how a future potential justice thinks about the public interest does kind of percolate back down into that decision making. Like if their view is very different from how the PUCO decided the case, they could find a way to say they didn't consider the evidence, they were unreasonable and unlawful in how they thought about the evidence. So I think those two things are interrelated.
And that settlement standard is entirely created by the Public Utilities Commission. It's nowhere in statute.
It's true, although the court unfortunately has upheld it repeatedly.
Yeah.
All right, I'm about to ask you a loaded question that I didn't warn you about, so you can also pass and I can just think of another one, which I have. But thinking about what you said about the data centers and the type of customer, like the lawsuit around the potential for just that targeted tariff to be itself potentially not seen as legal. Candidates have been talking a lot about data centers and how to regulate them. Have you found the way that candidates are talking about this to be sort of in line with your understanding of how these like practices and determinations are made? And that's all to say, like, are these things that are intended to target data centers, are they even going to be possible, like given the legal context that we are, living in?
So I do think the tariff that's, being appealed but is currently in place actually does achieve much of what it's seeking to achieve. The devil's in the details. There's more to do, I think, to really make sure data centers are paying their fair share. But I think that idea of getting data centers to pay their fair share is pretty bipartisan. And I do think the commission has tools available to ensure that. And I think there's like a kind of a more unified motivation to make that happen among parties that often fight with each other about other stuff. So on the electricity side, I think we do have the tools. Data centers raise all kinds of other like non-electricity related issues that, I think make things more complicated. There are still outstanding issues around how the costs are allocated that get way more wonky than we could do now, relating to how transmission costs kind of filter down to customers and that kind of thing. But I do think the tools are, I'm curious if Chris disagrees, but I do think the tools are there.
Yeah, I think we have the tools. I think it remains to be seen whether or not the plans that everyone's putting out are feasible. I think that's a different question. But the fact that everyone is talking about data centers, I think really demonstrates that it is the issue that is defining this election cycle in a lot of ways.
Total left turn, but I think hopefully it's a quick answer with a few minutes that we have left, and it came directly from the audience. But who or which entity oversees the possible CO2 recapture and sequestering? Like, which body does that fall under?
Yeah, the very quick answer to that is it's a combination of the Ohio Department of Natural Resources and the Ohio EPA, depending on the nature of the carbon sequestration going on. There is a bill that I think has either passed both chambers or just one chamber, I think both, that redid a little bit of the carbon sequestration policy in Ohio, but it's a combination of those two agencies.
Okay. And then a clarifying question we also got. I know you did say this, but I think it's worth emphasizing given all of people's feelings about tariffs. In this context, we're not talking about the typical tariff, right? Like that means a different thing. Can you just
Yes,
reiterate that point?
yes, this is not the same as the tariffs that we see in the news from the federal level. The tariff in this context is basically the utilities rule book and pricing rules for their customers. So each class of customers, residential, commercial, now data centers, has a tariff set of pages that the utility uses to then calculate your bill. So the tariff in this context really just means kind of their rule book for how the utility calculates a customer's bill.
Right. Well, thank you so much. Are there any we got somehow we still have 2 minutes left. So are there any final comments that you all want to leave the crowd with? Again, knowing that you all just hit us over the head with a ton of information, what is the thing that you most want to make sure we leave with?
Well, the biggest thing is that what I would say is that one, obviously, energy law is incredibly complex, and we talked about a lot of cases that showcase how these issues bounce back and forth. But what we didn't talk about is where the General Assembly comes in as well. And the General Assembly has been paying close attention to electric issues lately because of the rising costs. Like they're paying attention to data centers because their constituents are seeing rising costs. Erica, you made the point that just like the judges are electric customers, so are a lot of our legislators. And so this is a weird moment where like I do think there's an opportunity for us to continue to make a lot of progress on electric issues, both in these venues, but also at the State House, and then also ideally at the court. And so I just want to really emphasize that like don't underestimate the opportunity here where if maybe you're disillusioned about going and talking to your legislators about electric issues, they're listening on electric issues right now in data centers and stuff like that. They really are, both on both sides of the aisle.
Yeah, I totally agree. I think it's kind of nice as a really nerdy energy attorney to have the stuff I work on now be in the news and like be the like a normal topic for conversation. But people are, the public's paying attention. It is in the news, and there is a chance, I think, to influence these decisions from the outside. As Chris and I and our colleagues do the work from the inside. I think the public pressure through legislature conversations or commenting at the PUCO can really have an impact because they're paying attention.
Thank you both so much. Reminder, we will send around the slides from this. If everyone can join me in thanking Chris and Erica. This was wonderful, and I learned so much in an hour.
Thank you all. And if you are getting CLE credit, Jessica's going to put a form in the chat. This will also be in the email out, but if you're doing the CLE credit, please fill out that form for us. Then just a final reminder about our Utility Advocate Convening and Law Conference next month. Really hope folks decide to join us there.
Thank you, everyone. Good night.
Thanks all.